All rise. The honor rolls, the presiding judge, and the judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Well, good morning and welcome to the Court of Appeals. We have one case for argument this morning. Your panel this morning, I'm Judge Donna Stroud. To my right, we have Judge John Tyson. To my left, Judge Allegra Collins. And let's see, I want to make sure in this case that we have, I think everybody, the parties have decided how they're going to handle the time on the oral argument. That Chesapeake, as principal appellant, is going to argue first. Let's see, reserving time for rebuttal, about 18 minutes and reserving 12. Is that correct? Okay. And Centaur and the agency, let's see, Centaur's cross appellant. Let's see, you're going to divide your 30 minutes as you see fit? Sure. Is that correct? Okay. All right, very good. Okay, all right. And then Chesapeake, of course, has its rebuttal at the 12 minutes. And have you gotten all that? Okay, good. All right, so y'all have that all figured out. So that's wonderful. And then we are ready to proceed.
Thank you, Judge Stroud, and may it please the court. I'm Candace Friel with Nelson Mullins on behalf of appellant and cross appellee, Chesapeake Diagnostic Imaging Centers, LLC, which I'll refer to in short as Chesapeake. And with the court's permission, I would like to reserve 12 minutes for rebuttal. And I intend to address the argument of the principal appellant on substantial prejudice. And then my partner, Noah Huffstetler, will handle rebuttal and any response needed on the cross appeal filed by Centera. The ALJ committed reversible error in this case by determining that Chesapeake failed to demonstrate substantial prejudice as a matter of law. And we are asking this court to reverse and remand the matter to OAH for a ruling that Chesapeake demonstrated substantial prejudice by the agency decision and instruct the court to make findings on the allegations that were made on agency error. The focal point of our appeal is what is substantial prejudice? And we know the APA requires petitioners to show both agency error, which is self-explanatory, and substantial prejudice. And the substantial prejudice part examines really the question of, even if the agency made a mistake, why does it matter to the petitioner? And there is no right line, rule, or definition of substantial prejudice under the APA or our cases, but it is rather a very fact-specific inquiry. And all but a handful of the cases that have examined this question are in the context of non-competitive certificate of need reviews, where a petitioner did not get denied for an asset or something that it wanted. Instead, the petitioner was seeking to stop a competitor from getting something that they had applied for and been approved for. And that's where the courts have said a petitioner needs to show something more, some enhancement to be allowed to challenge and hold a competitor up from developing an approved asset. But that is the underlying context from which nearly all the case law on this subject has been drawn from. And very few cases from this court have looked at this question in the context of competitive reviews. For those petitioners, why does it matter? It matters because it's the end game, it's an all or nothing end game for those petitioners. You are either approved for the project you applied for and you can move forward, or you cannot. There are also, I would note, many competitive CON cases that have been heard by this court, but that do not address substantial prejudice at all. It is either assumed to exist, or at least it had gone unchallenged in those many other decisions.
Would you agree that the fact that the con was awarded to the other party per se does not show prejudice?
Your Honor, the case law has developed in that way, and so we are not arguing for a per se rule here today. We don't think the court needs to go there under the existing law and the facts of our case.
So if it's a binary decision, one party wins, one party loses. And that's that's the way that's the nature of the question, then what you would have to show some type of structural error or some type of prejudicial error in the process that led to that result. You cannot rely on that result itself. You agree with that?
I agree, Your Honor, that that's what the cases have said. I think that there's a quote that often comes from these cases that said the mere I believe it's the mere denial or mere status as a denied applicant is not sufficient alone to establish substantial prejudice. I think that might be where
That's
you're
exactly
going,
what.
Judge Tyson.
Yes. Mm-hmm.
And that's an often quoted statement, and that it was quoted in the one published decision before this court in the competitive CON context dealing with substantial prejudice, which was the BMA case in 2022. But it came out of an unpublished decision of this court from 2014, which was the surgical care affiliates case. And that decision was not binding on this court, and it actually, I tried that case on behalf of the appellee First Health, along with Mr. Huffsettler about a decade ago. So I'm very familiar with that case. And in that situation, the court was looking at a review where there were 28 acute care beds at issue, and the disapproved party, SCA, had been denied. And one of the arguments they made was that by virtue of being a denied applicant, they were an affected person under the CON law, and that affected person status equated to substantial prejudice.
Well, that would give you the right to bring the claim as the unsuccessful party. But then once you bring the claim, you would have to have a burden, would you not, in order to show some prejudice, something that happened during the process that was unlawful, illegal, or prejudicial to you, correct?
Yes, Your Honor, and it is that very piece of the fact that you're an affected person allowed to bring the petition where that language of being a mere status as a denied competitive applicant alone is insufficient. It was under that context. Right. And that case, SCA actually cited to Caramont, which is a decision from, I believe, the year prior to the SCA decision, and that was in the non-competitive context. And in the Caramont case, it was examining whether an affected person was sufficient, but affected persons under the CON law are substantially broader than just denied applicants, and they said that is not enough, you need an enhancement. And Caramont made that decision not based on looking at a denied applicant petitioner, but based on just a mere competitor petitioner.
Okay, so you have the status to be here as an affected party by the decision. So that's what gets you here. Now show us or tell us why there was error to warrant a reversal in what the ALJ did or what was done before the agency.
Yes, Your Honor. There are, I think, really boils down to 5 critical facts in our case that hit that bullseye of this sort of enhancement on substantial prejudice where other petitioners have fallen short in the past. In this case, first of all, unlike any other petitioner before the court in these past cases, Chesapeake was not an existing provider or competitor in the service area when it filed the application. The court has not seen that scenario. Also, secondly, wholly new for this court is that Chesapeake is seeking to insert or advance competition in a market that is controlled by a sole provider, Centera, for more than a decade. We are not seeking to use the CON law as a shield to protect against competition. We have no asset existing here to protect against. So we are not using it as a shield, but rather to insert competition, which is one of the core purposes of the CON law.
Can we just back up? You said you're not an existing provider. How would that, I guess, contribute to substantial prejudice?
Sure. All of the cases that we've seen examining substantial prejudice exist in the context of where an existing provider is either challenging their own denial or, most of the time, in a non-competitive context, challenging the approval of another applicant to do something with a new or an existing asset. We are not an existing provider using the CON law to shield, and that's been the problem that this court has found under the CON context, Judge Collins, because They have said that mere protection from competition is not what the CON law is designed to protect against, and that alone does not demonstrate substantial prejudice. We're different from that. We are not an existing provider in the service area. We cannot become an existing provider of fixed MRI services in the service area without first getting this certificate of need.
This was a new service though, correct? This was a con for an additional medical service. It wasn't a renewal or some type of expansion. This was either you get it or they get it.
That's correct, Your Honor. It was an all or nothing, which actually goes to another point and another distinction between our case factually. This was an all or nothing decision. We were not partially denied, we were fully denied. And as a result of that full denial, the decision came down to the Centera and to Chesapeake. And as a result of that full denial, we are not a worthy asset and cannot come into that market and provide that service or competition.
Are you not providing that service now?
We are providing a service in Virginia, but we are not providing fixed MRI services in the Pasquotank service area in North Carolina. And the way that competition works under the CON law, it's looking at the existence of an alternative provider in the service area question. Everything is broken into service areas.
So the state line is artificial. I mean, I know that you can be from Elizabeth City into Chesapeake in 15 minutes. So I mean, it's not like, if you look at it at a distance, it's closer than it would be from Fayetteville to Raleigh.
It is, but and under the CON law, the way it works, all of the county lines are artificial too, because everything is divided into these service areas. So even a provider in Wake County who has an MRI is not necessarily a competitor or a provider in a different service area, as those service areas are defined in the state medical facilities plan.
So it's not distance, it's just a state line on a map.
The state, perhaps I'm not
The
following your
difference
question
in the service area.
Service area.
Yes.
Yes, it's based on the service area, correct.
So in terms of people being able to access the care, it doesn't really make any difference if they're in Virginia or North Carolina?
I mean, Chesapeake will continue to provide its services in Virginia, and it will continue to serve Virginia residents, and it will continue to serve those North Carolina residents who go to Virginia for those services, whether because they live closer or they work in Virginia and drive in and it's more convenient for them. But the asset at issue here is an MRI to be located in North Carolina in the Pasquotank service area, and that is what cannot change.
Well, if I were having duck hunted up there, I know that it's easier to go from Elizabeth City to Chesapeake than it is from Elizabeth City to Currituck. So if I was in Elizabeth City looking for a service, I certainly wouldn't be driving to Currituck, even though it may be in the same service district.
Sure.
I know the prosecutorial district there runs all the way to Manio.
And I think that was one of our factual arguments with respect to agency areas, that we were providing a geographically accessible option that was enhanced from what Centera was offering, because we were proposing to put ours in Elizabeth City versus the Currituck location. And really the key here is our entry into this market where it has been entirely held for over a decade by a single provider, that we would also be introducing a choice for patients. So patients would then have a choice. If they wanted to go to Elizabeth City to our facility, they wouldn't have to go to Virginia.
As I recall, yeah, I know I had a case one time, I know it's a long time ago, I can't remember, but yeah, I remember the service areas are interesting because I think these were dialysis centers, and that was one of the issues in the case. Like, you might have a patient who's literally 5 miles from a dialysis center, but they're in one county that's not in the service area. Yes. But you can't count them because they're in the service area, and now they're 40 miles from the dialysis center that's in their service area, which kind of makes no sense, but they just look at it on service area.
I think the agency is not looking so much as at patients, but yes, the service area itself, and every applicant is permitted to define its patient service area and its primary and secondary service areas as they wish, and then of course serve whomever comes to them, regardless of whether they actually are from those areas.
It's sort of a legal fiction.
It is, Your Honor, and it varies between assets. As you mentioned, the dialysis, and that service area is different from an MRI, and here we have a 4-county MRI service area, and most of the time it's 1 county, largely dependent upon population. Yes.
So I had the first 3 I think, factors that you had listed. Is that correct?
Thank you, Your Honor. Yes, yes, that's where I was. And the other distinction that factually that makes this case erroneous from the decision of the ALJ is that Chesapeake's harm as a result of the agency decision was not speculative or hypothetical. It's very concrete and it's very real, and that's not what this court has seen in the past because, as I stated before, without that CON, Chesapeake cannot enter this service area and compete. It has no other option, and that was another distinguishing point in the surgical care affiliates case that we were just talking about a few moments ago, Judge Tyson, where the court also looked at the fact that in that case, SCA, although a disapproved applicant, it had a storehouse of hundreds of other beds that it could use and implement and operationalize to meet the need it projected. We don't have that here. There's one MRI. We don't have an existing one. We can't continue to serve patients on an MRI that we already have in North Carolina because we don't have that MRI in North Carolina. And our harm is not speculative because unlike the situation in SCA where certain equipment had not yet been operationalized, here we know the harm. We know what's going to happen without development of the MRI. In the other case, you had a situation where the petitioner couldn't really say what the impact would be if they put the beds that they had in storage, essentially, on simplifying, but online and actually utilize those. Then what impact might that have on their projected need? That's not the case here.
So one question I have, and Judge Tyson had talked about showing some harm in the process and getting there, and everything that you've listed is the result of the denial. When we look at substantial prejudice, are we looking at the result of the denial, or is there something that we're supposed to look at before that prejudiced you in not getting it?
It's substantial prejudice based on the agency's decision, the harm that results
resulting harm
from the agency decision. And that goes to the fifth point, which is that Chesapeake also here had a fully approvable application. And the ultimate decision by the agency that was on appeal came down to one comparative factor. And a comparative factor, is, I'm sure the court is aware, is not a statutory factor. It is not a rule-driven factor. It is a subjective factor that the agency calls it a factor, a subjective description that the agency uses to compare applicants one to another. They vary from application review cycle from one to another. They are not the same, and they are not derived from statute or rule. And again, that is another part of the error, in addition to our allegations of agency error with respect to determinations on the approvability.
Is that a subjective criteria?
The comparative factors, they are very subjective, Your Honor, because again, they don't come from statute or rule. The agency has a list of factors that it chooses from, and it varies from review to review. It varies sometimes from MRI review to MRI review, and none of those factors are set in stone.
Well, the fact that you had a fully approved application is what allowed you to actually be considered, correct?
To be
you would not have been able to even be in the decision without a, quote, fully approved application.
Yes, Your Honor. Judge Tyson, the agency would have still stepped through a comparative analysis of the two applicants, but we would not have been really in contention for it because by default, if we were not approvable, we would not have been.
So how can that be a factor when, again, that's what got you in the door?
That got us in the door, but it also, because of the way substantial prejudice case law, I think, has developed, what we typically don't see is a situation where it is a fully approvable application. There have been some, but here I think it is a distinguishing factor that we haven't seen in many other cases. For example, in the SCA case, where
well, I could understand if you had a fully approvable application. And the agency had said you didn't. Will you be arguing, yes, I do. You know, they erred by not giving me the consideration because I did have an approvable application, but that's not an issue here, is it?
That, not specifically, but that actually goes to the question of agency error, not substantial prejudice. So under the APA, we have to prove both agency error and substantial prejudice. And so we do contend that there was agency error. The ALJ did not reach the findings on the issue of agency error, which is one of the reasons we would like for the court to send it back and remand for findings consistent with a determination that we were substantially prejudiced. But substantial prejudice is the other piece of that puzzle.
I know we've asked you a lot of questions. Did you want to say anything else about exactly what was the agency error? I think that's what Judge Tyson had been asking you about.
I think with laying out the full context of this review being unlike any others that this court has seen before, and where this court has found substantial prejudice to not exist, I would just reemphasize we're in the competitive review context. The only published decision being the BMA 2022 case in the competitive review context that examines substantial prejudice is distinct. That was a partial denial because BMA was approved for 80% of the assets it sought, and that holding was limited to it being a partial denial and a lack of substantial prejudice in that vein. We're different here. Again, an approvable applicant losing on the single comparative factor, a new entrant into the market, which the court has not seen before, fully denied with no other option to meet the service, no other existing option or other option or storehouse, if you will, of options to meet those exact needs. And we believe all of that constitutes an erroneous conclusion of law by the ALJ that those factors do not equate to substantial prejudice. Our contentions on agency error with respect to the treatment of the applications, in particular the comparative analysis, weren't reached yet by the ALJ, but the record is replete with those as well, Your Honor. So for the reasons articulated, we do believe the ALJ erred in determining that Chesapeake failed to demonstrate as a matter of law substantial prejudice in this case, and we ask that the court reverse and remand with instructions for the ALJ to enter a final decision in determining that Chesapeake demonstrated substantial prejudice, and to further instruct for findings on the allegations of agency error under 150B23. Thank you.
All right, thank you. Let's see, who's next? Oh, you're going to do, okay, so you're doing, all right. I got you. You're doing this, okay. There's too many people here for me to keep up with. So, okay.
Your Honor, we'll take our full 30 minutes now.
Okay. Thank you.
May it please the court. Derek Hunter, Special Deputy Attorney General, on behalf of the Department of Health and Human Services. And again, I will, to the extent possible, I will use 10 minutes of our time and cede the other 20 minutes to Centerra's counsel. As the court is aware, under the APA, a petitioner must show agency error and substantial prejudice to be entitled to the relief sought. Those are independent elements, each of which must be proven. Here, the administrative law judge questioned appellant's ability to establish substantial prejudice based on the allegations in its petition, as well as its argument at summary judgment. However, the ALJ denied appellee's motion for summary judgment and allowed the case to proceed to trial. There was a multi-week full trial on the merits, and the ALJ entered a final decision holding that where all admissible evidence, even if taken as true, taking all of Chesapeake's allegations as true, Chesapeake failed to establish substantial prejudice. And a failure to establish substantial prejudice is fatal to its claim. Now, given that Chesapeake could not establish substantial prejudice, the ALJ affirmed the agency's decision to approve Centerra's application. On appeal, under the guise of a distinction between categories of CON applicants, specifically whether a petitioner actually filed a CON application or whether a petitioner is a denied applicant in a competitive review, Chesapeake invites the court to disavow decades of its own precedent and hold that Chesapeake was able to establish substantial prejudice by being a denied applicant in a competitive CON review and reverse the ALJ's decision.
Mr. Hunter, the argument that I heard is that they were prejudiced not by necessarily the outcome, but how that outcome was obtained. and she gave us 5 reasons to show that the outcome was substantial prejudice in the way that it was obtained.
And I will address, Your Honor, Chesapeake's allegations of substantial prejudice in turn. So for example, Chesapeake alleges that as a result of the agency's decision, it was substantially prejudiced by the fact that it cannot acquire or develop a fixed MRI in the Pasquotank service area. Well, that's the nature of the CON law. There is a determinative limitation on the types of healthcare services that the agency can approve in any given year. Here, there was a need for 1 MRI scanner in the Pasquotank service area, so the agency could only approve 1 application.
So is it the state's contention then that that's essentially a facial challenge to the con law?
No, that is not the state's argument. The state's argument is not that that's a facial challenge to the CON law. As a matter of fact,
I want to put it there. I can't put it there without the con approval, and therefore the con is preventing me from putting it there. Isn't that the argument?
that is
Isn't that a facial challenge to the con?
Your Honor, if this court were to hold that that was a facial challenge to the CON law, then such a challenge would be first addressed in the Superior Court before a 3-judge panel, and then I would imagine would make its way up to this court and through the appellate courts as well, which there is a current case pending. But
And there's a facial, the facial validity of the con law has been decided many times, correct?
yes, it has, and it's been held that the General Assembly, in the exercise of its police powers to statutorily regulate healthcare, is constitutional. Chesapeake also alleges that it is unable to compete on an equal footing with Centera. Now, the CON law is not designed to level the playing field between healthcare providers. Its purpose is to ensure that all North Carolinians, and particularly those in rural areas, are able to access necessary, cost-effective healthcare. Chesapeake also alleges that it was harmed financially by the agency's decision because it denied Chesapeake the opportunity to utilize its own resources to develop MRI services and generate charges for those services.
So I have a question. We've got a long list of the resulting harm here that was argued. And I understand your argument to be that none of those in combination or alone show substantial prejudice.
That is correct, Your Honor.
So what does substantial prejudice looks like?
Your Honor, well, I will first give you an example of what the courts have held substantial prejudice is. There is a case, hospice at Greensboro, where the agency permitted a hospice agency to develop a new hospice office in Guilford County without a CON. The court held that not having the CON process at all, allowing an applicant to develop a new institutional health service without a CON, is substantial prejudice.
So explain to me the difference then between agency error and not following procedure and the resulting harm that's substantial prejudice. That seems to me to be blurred.
Sure, Your Honor. And there are numerous appellate cases that hold that even if the agency fails to follow its own processes or rules, that is not per se substantial prejudice. The petitioner has a specific burden to show how the agency's error, if there's error at all, which we contend there was none, substantially prejudice an applicant. Here, there was no agency error, and all of the allegations by Chesapeake have been stricken down by this court as not constituting substantial prejudice because they are all competition-based results, and no provider, applicant, person, it has a constitutional right to be free from competition. So all competition-based claims through 30 years of appellate case law have held that competition-based claims do not constitute substantial prejudice. And that is the nature of all of Chesapeake's allegations of substantial prejudice. So the ALJ—
So you're saying the con law doesn't allow for participation trophies, right?
Absolutely. There is no participation trophy, Your Honor. And one of the things that must be, that I think I need to point out is, and this dates back to the Bridhaven case in 1995, so we're talking 30 years. The way the process works is each application is reviewed standing alone to determine whether it is conforming with all statutory and regulatory review criteria. It must be
And is
conforming
that
with all.
what gets you in the door?
Well, Submitting your application gets you in the door of the agency. The agency's decision gets you into the door of the court if you choose to.
And if you have a fully approved application, then you're allowed to compete.
Sure, you're allowed to compete by submitting your application, but here
A
is,
fully approved application.
sure. And
You could be put out for not meeting the criteria,
absolutely. And if you
height,
don't-
weight, whatever.
Absolutely. And if you don't meet the criteria, you cannot be awarded the certificate of need. The second part of the process is after the applications are reviewed to determine conformity, then the agency performs what is called a comparative analysis. Because, for example, in a case like this, there's only one asset. There's one MRI scanner. So there's only one applicant that can be approved. So the agency then engages in a comparative analysis. It chooses several factors, and typically the applicant that comes out to be most effective with respect to the majority of the comparative factors is the approved applicant.
Now-
That was the case here.
In that case, do you agree that those final comparative factors are subjective?
Subjective in the sense that they are not statutorily created, but the case law has held that the agency has the discretion to create and to employ the comparative factors that it chooses.
Well,
These
you would
compar-
agree they could not act in a discriminatory factor.
Yes, I do agree with that.
And so they could not use the mutable reason to deny.
I agree with that.
Okay, so even though it's subjective, there's still constraints on the exercise of that subjectivity.
Sure, subject to the agency's discretion, yes, but those factors are related to the application. And for example, geographic accessibility, which those factors are typically derived from the statutory review criteria and the findings of fact in the CON law. So they're not just arbitrarily chosen. These are well thought out comparative factors that are used to evaluate these applications.
And our standard of review or the ALJ standard review on that decision would be what?
On this particular decision, because he found that there was no substantial prejudice, this is a de novo review because that's an issue of law.
Okay?
So-
But in terms of a factual basis to support DHS's findings, would that not be, or do we not defer to their findings?
You do. The agency is entitled to deference regarding a statute that it administers. Certainly, the agency is entitled to deference here, unless its interpretation is unlawful, and that is
So
absolutely not the
Evidence
case here.
supports findings, findings support conclusions.
Absolutely.
And the only review, appellate review, would really be on a question of law.
No, sir. There could be a question on whether or not the agency was arbitrary and capricious. So there could be allegations subject to the whole record test if an appellate raises such an issue. But in this case, the only issue is an issue of law.
But that,
Whether or not
again, that
Chesapeake
would be
established-
deferential, would it not?
I'm sorry, say again, Your Honor?
That would be deferential to the agency on the whole record review.
If it were a whole record review. De novo, however, of course, is an issue of law.
Thank you.
Sure. Your Honor, Chesapeake also alleges its projected net income would not be earned as a result of the denial. It would be unable to earn net income beyond the 3 years projected. It would lose patience. It would lose capacity. It also argued that it would lose capacity in Virginia. And I would certainly note to the court that North Carolina CON law does not account for healthcare capacity in a different state. And I know there's been mention of the fact of the distance between Chesapeake and, for example, Elizabeth City, but that has no bearing on North Carolina CON law. So, Your Honor, I had the pleasure of arguing the BMA case in 2022. And in that case, published in this court, so definitely binding, in that case, the petitioner also alleged that the petitioner did not prove substantial prejudice. The difference between the BMA case and this case is that the ALJ actually granted some discretion because all of the claims were competition-based to the extent that they were even raised. And this court affirmed. So there is an example of a denied applicant in a competitive review that failed to establish substantial prejudice, and its case being dismissed and affirmed by this court. And I would argue that that is binding on this court, that 2022 BMA case. So in all, the agency's position is that because it did not commit agency error, the ALJ was correct in not having to even reach agency error, and holding that because Chesapeake failed to establish substantial prejudice, which dates back nearly 30 years in the appellate courts, all of its claims being competition-based, the ALJ did not err in its final decision, affirming the agency's decision to approve the Centera application, and the ALJ's decision should be affirmed. If there are no additional questions, I'll cede the remainder of the time to Centera's counsel.
Thank you.
Thank you, Your Honors.
May it please the court. My name is Alexander Gormley. I'm counsel for Appellee Cross Appellant Centera Advanced Imaging Solutions, LLC. I'd first like to discuss Chesapeake's appeal, followed briefly by discussion of Centera's cross appeal. Before delving into the substantial prejudice argument, I think it's important to just zoom out and look at the agency's decision overall. It was a close one. Both applications were found conforming, and then they applied a number of comparative factors, and Centera won 3-2. And what tipped it was they won on geographic accessibility, because they proposed to put their MRI in Currituck County where none exists, whereas Chesapeake proposed to put theirs right on top of the existing MRI. So I think the agency exercised a lot of wisdom and common sense and found this is the better application. It's going to spread these MRIs throughout the area. And with that in mind, we have to look at the rest of the case, which is Chesapeake then petitioned. It had a 14-day hearing, had every opportunity to put on its case for substantial prejudice and agency error. Judge Byrne was not swayed, and he affirmed the agency on the basis of substantial prejudice. He affirmed it because he followed the law of this court, in saying whatever substantial prejudice Chesapeake has alleged falls squarely within what this court has said it is not. And these are the same things that they've alleged here. So I cannot, on the basis of the law that I'm bound to follow, find that there's substantial prejudice. On appeal, Chesapeake wants the court to do what it asked Judge Byrne to do, which is basically make a new rule as to what substantial prejudice is, and say, in this particular unique circumstances, because we're not an existing provider in the service area, and we were an actual applicant who was denied, that means we proved substantial prejudice where others have failed. And I would respectfully submit that this court, in its role as an error reviewing court and not a rulemaking court, should not make that rule. And I would submit that Judge Byrne followed the law and made no error. He followed the law scrupulously, and I have not really heard any arguments that he did not follow the law scrupulously.
Let me ask you this, other than immutable discrimination, what would support a showing of substantial prejudice?
Well, I think that's an excellent question, and one that gets overlooked, I think, a lot in the briefing and even in the discussions of this issue, which is so interesting, is it's substantial prejudice of a right. It's somehow morphed into this idea of harm, and I would acknowledge that harm and rights can have some overlap, but I think you really have to look at what is the right that's been substantially prejudiced. Chesapeake has not identified that here, and Judge Byrne zeroed in on that. You don't have a right to patients and revenue. You don't have a right to just go into a service area. You have a right to compete in the sense that you have the right to apply for a CON. And that's exactly what this court said in the biomedical case from 2006, where the petitioner brought a declaratory judgment action. They said, wait a minute, you haven't been denied the opportunity to compete. You submitted an application. That's competition right there.
So once you have two qualified or multiple qualified applicants, here's two, right? Just two. And it's a binary decision, correct?
Correct.
Describe to me again, I'm trying to rephrase, where would be an example of substantial prejudice other than discrimination between two equally qualified applicants?
Sure. I think a good example of that would be in the Duke case, where Judge Byrne found that the agency substantially prejudiced the petitioner's rights because in reviewing the applications, it imposed a requirement that's not in the review criteria. The agency said, tell us, applicant, why you petitioned against the need previously and now you're applying for it. And it held that against them. And Judge Byrne, I think, very wisely found, listen, that's not part of the CON review criteria. I get that it's sort of an argument that the competitor would make that this isn't very fair, but as long as the law says that you can petition against the need and then turn around and apply for that need if one is found, then the agency can't hem you up on that, and they certainly can't go outside of the statutory criteria and apply that.
Would Chesapeake be entitled to know the subjective comparative criteria that the agency was using?
They are and they were.
Well, I've heard that it's not in the statute, it's not in the rules. So where is it?
It comes out in discovery. So in discovery in this case, Chesapeake deposed the agency analyst and was able to ask them about the review process and the factors selected and what they did. They did not argue to Judge Byrne that that process was prejudicial or erroneous at all. What they argued was the application of the factors themselves, meaning what they decided, was wrong because they felt that Chesapeake was superior on more factors.
So result, outcome, not process.
Correct.
So can you explain to me, you gave us an example of error where the agency might have applied a factor or a fact that it wasn't supposed to, as an example of prejudice? Did I misparaphrase what you said?
Yeah, I'll try to answer this. I'm not aware of a situation in which substantial prejudice has been claimed as a result of the agency's application of the comparative factors or using a comparative factor that a party felt was not warranted or was discriminated.
Okay, so I'm going back to the example you gave of what might be substantial prejudice, and I'm still having trouble distinguishing between agency error in the process and the substantial prejudice, because you have to have both, correct?
Correct. What I think Judge Byrne decided there is you have a right to apply and have your application reviewed based on the criteria. If the agency comes in and imposes another criteria, that's not only error by the agency, but it's an infringement or prejudice of your rights because they are going beyond what the statute affords you as an applicant. And so in that situation, I think agency error and substantial prejudice can be one and the same. And I think that's still consistent with the law that says merely being a denied applicant is not enough. You can show if the error was bad enough or intertwined enough with the right, I think you could establish substantial prejudice. Here, we're not dealing with that situation.
Going back to the Duke case, the prejudice there was the agency's error in bringing in a criteria that was not stated.
That is my understanding, Your Honor.
Okay. So again, I go back to this subjective analysis criteria, not in the rules, not in the statute. And I presume that if the parties are aware and have to meet, they each have to address that, then that's a fair process. But that's the hang up I'm having here on the agency applying rules or applying a standard that is not in the statute and not in the rules.
Sure. And again, my understanding is the agency applied that non-existing rule in the review of the criteria, which was the step it took before then going to the subjective factors. So the error was in the objective application of the statutory criteria before it reached the subjective comparative factors.
So that's what separates the Duke case from what you're saying here today.
Yes, Your Honor, I believe so. I believe Mr. Hunter hit on it well when he said the biomedical applications case from 2022, which is binding on this court, tells us all we need to know. Again, it said mere status as a denied applicant is insufficient to establish substantial prejudice. And it also talked about how being subject to increased competition is not subject to substantial prejudice. And I recognize that Chesapeake has done a valiant job of saying, we're not saying we're facing increased competition. We're saying we can't compete in this area. But I would argue that's a distinction without a difference because of the CON law that says the right to compete is the right to file for and apply for a CON. It's not the right to be in that market. So at bottom, the allegation that being denied means they can't put the MRI in that area is no different than the underlying allegations of the many denied applicants and the many substantial prejudice cases where this court has said you're just making a competition claim, and I'm sorry, that's not what substantial prejudice is. I think the surgical care affiliates case from 2014, which is unpublished, is also helpful, though, because there the court rejected the denied applicant's argument that it was substantially prejudiced because the denial of its application prevented it from alleviating capacity constraints at its hospital. And the court looked at it and said, well, that's factually not true because you've actually got existing beds that are unused. I would argue the same rubric could be applied here. As Judge Tyson hit on, Chesapeake already serves patients in this market. In fact, their application said, if our MRI is here, we're just going to keep on serving the people from the 4-county service area who already travel up to Elizabeth City, because as Judge Tyson hit on, it's a lot easier for most people to do that. So Chesapeake is not being denied access to this market, and it does have sort of a safety valve or relief from this decision. They can continue to treat these patients, and there's nothing, as far as I know, that would stop them from growing that Virginia center, from offering a better service. I often like to tell my clients in illegal non-compete cases, I say, I get you're frustrated, but we're going to handle the legal side of it. You're going to handle the side of going out and beating this competitor in the marketplace. There's no better antidote to relieving yourself of harmful effects of government action, if that's what you're alleging, than going out and just being the best provider in the marketplace. Another point, which Mr. Hunter briefly touched on, that's been articulated by this court over and over again, is that claims of financial harm, especially speculative claims, do not establish substantial prejudice. I think that was well articulated by this court in the other surgical care affiliates case from 2014. That was the published one. And there, the court said, your claims of financial harm are speculative. You come in and said you're going to lose out on this revenue. Okay, that's just, all that means is that you've been denied. That's basically what Chesapeake did here. They said, by being denied, we are going to be deprived of the 3 years of projected revenue in our application. They did not put on any econometric analysis that said, here's how much we're going to lose on a global basis. We're not going to be able to backfill that. And in fact, if we open that up, we'd be able to increase capacity at our Virginia facilities by X number of dollars. They just made a very conclusory, we're denied that application, we're denied that MRI, we can't make that MRI, we can't make that revenue. And this court has already said, that's not enough. That's not substantial prejudice, especially because going back to the Caramont case, this court has rightly said, no one has a right to revenue. So by saying you've been denied revenue, you can't say your rights have been substantially prejudiced.
So your argument is not that they didn't put on enough evidence, that it doesn't matter what kind of evidence they put on of lost revenue. That's not something to consider?
My argument would be both. And that was one of the basis of our cross appeals, which is that Judge Byrne accepted those allegations of financial harm as true, whereas we thought that the evidence was not sufficient to support a true showing of financial harm. It was just speculative. And with that, I'd like to briefly segue to Centaur's cross appeal. I think it hinges really on another question of, did Judge Byrne err? I hate to say he was so great on this one thing, but he really messed up on this one. And I don't think he messed up. I think he did make a subtle error in deciding that he could not address the issue of Chesapeake's authority because it was not in front of the agency or something the agency decided. He relied on Craven. And I would submit that Craven is distinguishable because there, the petitioner wanted the court to consider North Carolina's statute that's outside the CON law on self-referrals and said, this applicant's in violation of that, therefore they can't comply with the review criteria. The agency said, we're not going to review that. It's not part of the review criteria. The court affirmed. This is a little bit different because we're not asking Judge Byrne to decide agency error by looking at Chesapeake's lack of authority. We're asking him to decide substantial prejudice. And substantial prejudice is not something the agency reviews. It's something that the ALJ reviews as a matter of first impression.
Are you referring to the state of incorporation or the situs of the applicant? Is that?
I'm referring more specifically to Chesapeake's unique corporate structure where it's the wholly owned subsidiary of Chesapeake Regional Healthcare, which is actually formerly known as Chesapeake Hospital Authority.
And that's a corporation, Alabama corporation, correct?
Chesapeake itself is the wholly owned subsidiary.
So let me just ask the question, is there anything in the con law that would prohibit a healthcare provider who is licensed in another state with affiliates from filing a complete, accurate con application?
Candidly, Your Honor, not that I'm aware of. Our argument is based more on corporate law, and I hate to oversimplify it, but I think common sense. I think our argument is the parent company is limited in its ability and must act in all respects for the benefit of Virginians. And our argument is those restrictions flow down to its subsidiaries. And as a result, in creating Chesapeake as a subsidiary to build an MRI in North Carolina projected solely to serve North Carolinians, that project is not for the, in all respects, which is the language in the statute, quote, for the benefit of Virginians, and therefore it was ultra vires. Now, Judge Byrne, he liked the argument, but he said, I can't review it because the agency didn't review it. And what we're arguing is, I don't think Craven so restricts you because you, Judge Byrne, had the right to review substantial prejudice. That's your bailiwick. And Brithaven tells us that the scope of the review is the agency's decision based on the evidence presented to it or that was available to it.
How can you raise that as an issue of substantial prejudice when you were the winner of the application?
Well, our argument is that it's an additional ground for substantial prejudice. It almost, substantial prejudice in a way is a threshold issue, and we say that this is almost the threshold to the threshold issue.
So that's a procedural issue. That's a threshold. Are they able to be a qualified applicant, right?
Correct.
And are they licensed to do business in North Carolina?
Chesapeake is licensed to do business in North Carolina.
So we have foreign corporations filing here all the time and get a certificate of authority in this state.
And that's not our complaint with Chesapeake's structure. Our complaint is that its project and what it's doing is beyond the powers of the Chesapeake Hospital Authority authorizing statute, which effectively authorizes existence.
But that's a, excuse me, I'm sorry, that's a Virginia statute as applicable to an Alabama parent company, correct?
That is correct, Your Honor.
You sure you want to go there?
Well, we thought it was an argument worth making, and we thought that there was, based on Craven and the fact that the information that the ALJ would have needed to decide everything was within Chesapeake's application. If it was outside of Chesapeake's application, we would not have gone there. But its application had everything the ALJ needed to review to decide this. Assuming you think he can decide issues of corporate law and Alabama law. If he can't, then I think, candidly, we know where we stand on that issue.
Let me ask you, other than corporate status, was there anything in their application that was non-conforming?
We did argue that at the trial level, so if this matter to be remanded for Judge Byrne to decide agency error, then that would be something that he would take up, and he'd have to review our argument.
What was your argument?
Your Honor, it's been a little while, and I've been so focused on substantial prejudice, but I believe we argued that they were not conforming with several factors, and we also argued that they were not, several of the review criteria, I should say, and we also argued that they were not more effective on some of the comparative factors that the agency found they were effective.
Did you bring that forward before the ALJ?
We did, yes.
Thank you. What would you have us do?
I would have you affirm the judge's decision on the basis that he did. If for some reason you find that he would erred in his substantial prejudice ruling that he made, we would ask that you decide or remand and have him enter ruling in our favor on the substantial prejudice issue that we've argued regarding the corporate status.
All right, thank you.
Thank you.
Rebuttal.
Thank you, Your Honor. May it please the court. I'm Noah Huffsteller from Nelson, Mullins, Raleigh, and Scarborough here on behalf of Chesapeake. I will not spend the little time that I have dealing with what the purported cross appeal. Our brief shows a half dozen reasons why that should be rejected. I'll stand on just the first one, which is Centerra got all of the relief it requested below. Therefore, it is not under the law an affected party who can bring an appeal under General Statute 1-271. What Centerra is actually trying to do is to suggest an additional basis for the decision in its favor. There's a way to do that under Appellate Rules 10C and 28C, but it is not by filing a cross appeal. So this court simply has no subject matter jurisdiction over the matter. I'll stand on that. Judge Collins, you asked the question this case is all about. What is substantial prejudice? I will take some responsibility and apologize for creating some of the mess because I was the one who argued the Caramont case. And that was a great example of what is not substantial prejudice. Caramont Healthcare in Gastonia wanted to build a satellite emergency room in my old hometown, Mount Holly, which is right across the river from Mecklenburg County. And the hospital in Charlotte, Carolinas Medical Center, didn't want them to have that. They didn't have a competing application. They just did not want to have more competition from a facility closer to Charlotte.
And it was a different service area too, correct?
Yes, sir. So bottom line, that was what started all this problem. And since then, this court has frankly decided in all kinds of ways. It frequently simply allows the case to go forward without considering substantial prejudice. It sometimes has ruled in ways that are more limited than what is being argued now, but using language that's not precise. For example, the BMA case. That was a case that involved an application for dialysis stations, and the petitioner got 10 of the 12 that it wanted. And the court said, well, just the fact that you got 80% rather than 100% of what you asked for, that's not substantial prejudice. But I would answer your question, Judge Collins, in this way. If a new provider seeking to come into an area and needing a certificate of need is disapproved, and that disapproval is based on agency error, and that is not substantial prejudice, then in the CON context, nothing is. Who could bring a case? I would suggest to you that it essentially eviscerates the law, the Administrative Procedure Act, with respect to the certificate of need process. And I would also suggest that if you think about it, there are a lot of businesses in North Carolina and individuals who need a license or a permit to carry out their business in this state or in a part of it.
Including licensed attorneys.
Including licensed attorneys. And if that person is turned down and that decision is erroneous, then if you follow Centerra's argument here, you have no right. No one does. I would suggest to you that that, and this decision in particular, is in violation of Article 1, Section 19 of our Constitution of the state of North Carolina, the Law of the Land Clause.
Wouldn't that be a facial challenge?
No, sir. It would be an as-applied challenge because here we were not permitted to have a judicial, we would not be permitted to have a judicial review of a decision. In other parts of the CON law, you could challenge it. It's here just because of this substantial prejudice issue. I believe that it's time to clarify, and if you look at the portion of the transcript that we included in our papers, the Supreme Court is right now struggling with this issue in the Pinnacle case. And my old law partner, Justice Dep't, asked some very pertinent questions. The question that you asked, Judge Collins, what is substantial prejudice? This isn't. And we expect that decision to come down shortly. But I would implore this court to clarify the case law that has been all over the place and hold that if the agency commits an error that results in a decision of disapproval, that is substantial prejudice. And you asked Judge Tyson about the comparative review. Our contention here is there should have been no comparative review in this case. The case should have been decided on the fact that Centerra does not comply, or its application did not comply with criterion 18A in the statute. That criterion basically says, show us the effect of your proposed project on competition in the proposed service area and how your project will enhance competition. And it gives another alternative. It says, if your project will not enhance competition, tell us why that will not result in better service, lower prices. Tell us why competition is unimportant here. Centerra didn't take that channel, that branch. It argued that its project would enhance competition. And that's pretty rich, since for 5 consecutive years, Centerra petitioned the State Health Coordinating Council, which decides what facilities and services are available in any place in the state. For 5 consecutive years through 2021, they said, we need another MRI machine in this 4-county area. For 5 consecutive years, Centerra petitioned to take that need out. Said it was not needed. And then finally, with respect to the 2022 plan, Centerra did it again, tried to get that need taken out. Chesapeake opposed that, said, yes, there is a need, based on your methodology and our results. Was successful, and so this, for the first time in 10 years, there was an opportunity to add a new competitor in the area. Having 5 consecutive years argued there was no need, when the need was shown in the plan and could be applied for by somebody else, Centerra flipped 180 degrees and said, not only is it needed, but we need it here in our facility.
Did circumstances change during those 5 years? More people move in? The need became apparent later on?
That was not the situation here, Judge Collins. That could have been the case elsewhere, but the SHIC, the State Health Coordinating Council, has a standard methodology that it follows to determine where a need exists. And in each 5 of those years, their standard methodology applied to the population of the area in that year showed a need. So it wasn't something that changed over 5 years. Each year a need was shown. Each year Centerra canceled it out, persuaded the council to cancel it out. Then when we were able to get the State Health Coordinating Council to recognize the need, Centerra applied for it. We would suggest, members of the court, that that indicates that there's no possible way that approving the Centerra application, the monopolist who had the only service within that service area to supply MRI procedures, approving their application and denying the application of a would-be competitor, there's no way that conforms with criterion 18A, particularly given the undisputed facts of how Centerra over and over had attempted to prevent the need from being recognized. So I would answer your question, Judge Collins, by saying if this is a substantial prejudice, then no one who needs a permit or a license or a certificate of need and is disapproved because of agency error shows substantial prejudice. And none of those people have the right to judicial review as guaranteed in our Constitution, Article 1, Section 19. I would be happy to respond to any questions.
What would you have us do?
Have you reversed the decision of the ALJ, send the matter back for, we had no findings of fact even in this case, or insufficient findings of fact, send it back for findings of fact and conclusions of law and allow the case to proceed. Thank you, Your Honor.
Thank you all very much for your arguments, and we'll be
All-
adjourned.
All right. Court adjourned.
Do more than less.